Good evening. Welcome, everyone. Thank you for joining us this evening. My name is Jenny Mattingley, and I am the Vice President of Government Affairs at the Partnership for Public Service. For those of you not familiar with the partnership, we're a nonpartisan nonprofit working to build a better government and a stronger democracy through policy ideas to make government work better, leadership development, workforce programming, and convening conversations like this one to help support the federal workforce. We know many of you are here because you have a lot of questions, especially about the executive actions and guidance that has come out over the past few weeks, how they impact you and your colleagues and your agencies, and all the work that you do as well. We also know there's a lot of confusion out there and anxiety as well. So much of this is happening quickly without a lot of time to work through it all. So we're here trying to help you navigate it and make sense of some of those things in real time. And we know that those of you listening as well who work in government really care about public service and are worried not just about how these actions will impact you and the people you work with, but how they'll impact people across the country and around the world who rely on and interact with our federal agencies and programs. So we're here to help support you as best we can through resource sharing, plain language explainers, and continuing to do what's a hallmark of the partnership, which is sharing all the stories of the incredible work that federal employees do around the country. So before we get started, for those of you feds and current and former out there, thank you for your service. We see you, it's noticed, and we really appreciate you. With that, I'm going to make a few quick housekeeping notes, introduce our panelists in a moment, and then we'll dig into today's content on whistleblower processes and protections. Before we kick off, a quick disclaimer. The content provided during this session is for informational purposes only. It's general and it provides an overview of the typical processes around various employee actions, and it is not intended to provide any legal guidance. If you do require legal advice, we recommend consulting with a qualified attorney who can assess your unique circumstances. As I mentioned above, we're doing our best to dig through and analyze all of the issues and things that are happening in real time. And unfortunately, they often leave more questions than answers at this point, but we will provide you sort of broad understanding and overview, particularly of the whistleblower process and what some of the current laws, rules, and actions are, and generally how employees navigate whistleblower protections. Throughout the webinar, we will answer questions that you submitted while registering. You can also submit a question anonymously through the Q&A function, and we'll work to get through those as well. We unfortunately won't be able to answer every question tonight, but we will certainly have a series of explainers over the next few weeks as we continue to dig into topics, so keep an eye out for that. And we'll also have more resources on our webpage as well. Finally, this discussion is geared towards current federal employees, but it is an open forum, and we may have folks joining us from outside communities around the good government sphere, media, private sector, and we welcome you here, but just wanted to flag that this is really talking about issues that will impact federal employees currently. And then if your specific question is not answered tonight, or if you have more individual circumstances that you want to dig into, again, we encourage you to reach out to your agency HR staff or seek legal guidance from your agencies or an outside attorney. And then just continue to support each other. Before I go on, I would like to introduce our two guests this evening, Dana and Joe. Could I ask you each to introduce yourselves? Dana, I'll give it to you first, and then Joe.
Sure. Hi. This is such an honor to be here. We've all, Joe and I both, our organizations for so many years have worked with federal civil servants as really important guardrails, the best guardrails against fraud, waste, and abuse. And whistleblowers are a piece of that, and the rights to speak out about that. And so this being able to be with you tonight to give you some education is just really an honor. So my name is Dana Gold. I'm an attorney. I am Senior Director of Advocacy and Strategy at Government Accountability Project, which is a nonprofit, nonpartisan organization that for nearly 50 years has promoted government and corporate accountability by protecting whistleblowers and ensuring their disclosures make a difference. And we do that by centering the employees' rights to report problems, serious wrongdoing, but then moving their information, including with partners like Pogo, Joe will introduce him in a second, to Congress, oversight agencies, directors, the press, public interest partners, to leverage information to make the gears of democracy work, and promote accountability and reform. So that's what Government Accountability Project does. I lead us in that work, and I'm really honored to be here.
Great. Thank you, Dana. And Joe, over to you.
Hi, everyone. I'm Joe Spielberger. I'm a senior policy counsel at the Project on Government Oversight, or POGO. POGO is a nonpartisan independent watchdog organization. We combat fraud, corruption, abuse of power across the federal government. And for the purposes of this evening's context, we are very experienced in working with whistleblowers and sources inside the government who come forward with information. We can investigate that wrongdoing, publish findings, and use that information to lobby agencies to take action, to lobby Congress to exercise better oversight over the executive branch, or use findings to inform policy reforms for legislative advocacy as well. So we're very grateful for the partnership and for our friends at GAP, and we look forward to this conversation and ensuring that people understand the rights and protections, how these play out, and resources available so that you can be sure that you can navigate these situations.
Great. Thank you both. Before we dig into everything, I just wanted to mention for everybody watching that my colleague Jackson is on the line, and he might appear on screen all of a sudden. He's monitoring the questions that are coming in through the Q&A function. And so if you see him join us on the screen, it's because there's a question from the audience and he'll hand us those. So at any rate, why don't we dive right into the real bulk of the discussion here and set the stage on what whistleblowing is. I think people generally know, and you mentioned waste, fraud, and abuse, but if you could talk about what it is, what types of things constitute whistleblowing, and sort of what a civil servant's role is in whistleblowing, that would be great. And so maybe Dana, I'll kick it off to you first. Joe, jump in as well.
Sure. My colleague Tom Devine, who's he's been one of the authors and leaders of the Whistleblower Protection Act and helping draft and pass most of the federal laws that protect whistleblowers now, describes whistleblowing as using free speech rights to expose abuses of public trust. And he's a lawyer too, but I choose a more narrow definition kind of rooted in the law, which I think is useful for talking about rights, which under the Whistleblower Protection Act, which is the primary federal law that protects federal civil servants, the majority of them, with some exceptions, and we can talk about that if we need to later, but it defines whistleblowing as information disclose that when an employee discloses information that they reasonably believe evidences a violation of law, rule, or regulation, gross mismanagement, gross waste of funds, abuse of authority, or a substantial and specific danger to public health and safety. Now, that's not the only definition of whistleblowing, because there's a legal patchwork with lots of different laws out there that is probably maybe a different conversation to have. But it's a good, I think it's a good definition to think about whistleblowing, because one, it talks about the fact that employees are usually the ones that are certainly have the rights, not always, so again, everything, because we're a lawyer, everything's an exception, but that employees are the ones that we recognize are in the best position to see wrongdoing and problems in the workplace, so they can mitigate problems, right? Or prevent them. They're in the best defense because they have like a firsthand seat. They're also the most at risk of retaliation. So that's why we have employment protection schemes. They're largely anti-retaliation schemes to allow employees to report problems. And when we talked about that list of problems, it's serious. It's not, stealing a pad of Post-its from the office supply cabinet. Now, that might not be right. It may not rise to a level of a serious, substantial and serious threat to public health and safety, or gross mismanagement, or gross waste, right, or illegality even. And so the reason why these the kinds of things one can blow the whistle on are serious are because, again, it's like employees as guardrails and employees as protectors of the public interest. And so these are it's the content of the speech which is serious, that gives rise to the level of protection of what rises to a level of whistleblowing. So that's why I think about, I don't know if that definition is helpful, but I think it's rooted in law, and it also explains the nature of what is protected speech, is what we would call that. And Joe, you may have examples, which I can talk to too, but you may have examples of the kinds of things that fall into those categories, because you guys have been as active on this as we have over time.
Yeah, definitely. So just to kind of underscore what Dana is saying, at a higher level, throughout our country's history, we've really relied on whistleblowers to help us protect our democracy, our economy, public health and safety, national security. They've played such important roles in allowing Congress to better exercise its oversight authority, to allow the media to better report accurately on what's happening and to sound the alarm so that the public has a better understanding of what's happening in our government, and we can work to hold people accountable. There are so many notable examples throughout history that a lot of people are probably familiar with. People like Deep Throat during Watergate, folks like Daniel Ellsberg, who exposed the Pentagon Papers during the Vietnam conflict. More recently, we've seen a lot of high-profile whistleblowing, especially in the intelligence community, and contractors around mass surveillance, for instance. But whistleblowing really touches on so many different issues across different agencies and different spheres. So anything from, blowing the whistle on immigration detention facilities and conditions therein, issues around medical malfeasance and neglect in VA facilities across the country that have direct life and death consequences for veterans and the amount of care and standard of care that they are able to receive, agency responses to discrimination and harassment, censorship of public health data, issues like the illegal withholding of congressionally appropriated funds, violations of civil and human rights. And so the list really goes on and on. But I just really want to underscore that, the importance that whistleblowers play, not just in helping us better combat wrongdoing across the federal government and increase government accountability, but the really strong role that they can play just to protect our democracy right now.
Well, and I think that's a good point, because you mentioned the role that these employees play, and Dana, you mentioned rooted in law. Are civil servants required to talk about or call forth, blow the whistle when they do see something that rises to the level of whistleblowing? Because my understanding, I think there is some rooting in law about what the responsibility of civil servants is.
Yeah, I think it's a complicated question. I mean, civil servants take an oath, right? They take an oath to the Constitution and to fulfill the mission of their agencies. That's why we have a nonpartisan civil service. The Civil Service Reform Act protects a nonpartisan civil service, and in part rooted again in that commitment to the rule of law, to the Constitution, and that creates in itself a duty. I think there are different layers of duties depending on the nature of the employee, right? If you're a lawyer, you also have this extra layer of duty because you're licensed as a licensed attorney. Engineers and doctors, like engineers have professional licenses, for instance. You have medical doctors who have a duty because they took a separate oath, of do no harm, right, in medical context. So we represented immigration doctors and nurses in immigration detention contexts who have had to blow the whistle because what they have seen would basically put their own license at risk for not reporting, for instance. So I think another blush on this is that under the law, the Whistleblower Protection Act protects duty speech, right? It protects speech by employees who are speaking in the course of doing their duties. It is a higher standard legally. You have to show reprisal and not just that retaliation was a contributing, like the speech was a contributing factor. So it's a higher standard of proof, but it is protected. And we see that because so many employees, it goes to the kind of the, I don't know if it's quite the duty question, maybe it's a different blush on the question, but so many whistleblowers don't see themselves as whistleblowers, right? They're like, I was doing my job. I was doing my job. I'm a quality control inspector. I reported, failures, like on this pipeline, right? Or my job is an auditor. Like I am supposed to, like I am doing my job in reporting, and now I am suffering consequences for doing that. I am prosecuting crimes, and now I am being told that is a problem, right? That's why the law protects duty speech. It protects the right to speak up, as well as recognizing that there are employees who are literally, by definition of the nature of their work, empowered / required to speak up because that's the nature of their job. And so that's why these protections are super important, to retain and strengthen and exercise, because again, that's how we protect democracy. It's how we promote accountability, and we need the power of the frontline human, right? The speech doing, the person exercising their right to speak up, is basically the vehicle that's holding us together, to make sure that the institutions of accountability work. I don't know if that, Joe, I don't know
Yeah.
if you have anything to add to
Joe,
that,
do you
but
have anything to
Well,
add?
I'll just add really quickly that there is actually an executive order that George H.W. Bush signed back in the day that does require employees to disclose evidence of waste, fraud, abuse, and corruption as a way of upholding ethical standards across the federal government. That being said, as Dana is alluding to, it's definitely one thing to have a duty and an obligation and have protections that exist on paper, and really recognizing the limitations of those rights and protections, the limitations on enforceability, and really how these risks play out in real time.
So one of the things that you both said that I'm curious about, and I suspect others are curious about too, listening to this, is where do you, to become a whistleblower, where would you make those disclosures to? Because we've talked about, in the course of work or in the, other things. So is it just at work? Is it to Congress? Is it to outside groups? Could you talk about that a little bit? And I don't know which of you wants to jump in on that first.
Yeah, I don't know. I don't know who always go first, but I'll talk a little bit about this, because I think it's it kind of goes to that point that most people don't think of themselves as whistleblowers, and I think it's first, and it's so interesting because I don't, this is an old statistic, but I think that it is still true that the majority of whistleblowers report internally first. Indeed twice before they ever go outside. And I think there's a misperception, for instance, that whistleblowers are only people that have gone to the press. And that is so dangerous. It's like it's if you're a manager, like that's a really wrong-headed, that's not going to serve you well. To not know that is not true, that you have a lot of opportunities and avenues for disclosure as an employee, and to be protected in raising concerns. So you can raise things to a manager, to a supervisor, to even a coworker, to an ombudsperson, like inside the organization, to HR, someone who has authority within the organization to do something about the issue. You can go to the Office of Special Counsel, which is there to receive disclosures from federal employees. You can go to an inspector general. And there, again, the legal patchwork is different, for lots of different status, but we're focusing on civil servants tonight. Military have different routes that they have to take. So this is not legal advice, and the one takeaway is call a lawyer before to help you walk through your rights, but and how to do it. But basically, for general civil servants, is that you can go to Congress, you can go to the press. That's how Congress gets their information. So there are lots of different ways that you can disclose information in ways that are considered protected, and to do that with rights to do so without suffering a prohibited personnel practice, or a threat of a prohibited personnel practice. So, and it's not just termination; it can be, it can be a poor performance appraisal. It could be having your work duties changed. I mean, it's very broad, the kinds of personnel actions that are prohibited for to take against someone who is raising a concern. And there are lots of different routes to raising concerns. That doesn't mean they're all protective as each other, right? Like, so how you make those choices really matters in terms of how to be safe and effective with the information. So so we can talk about that. Like, so for instance, if someone wanted to retain their confidentiality, for instance, very tightly, how they may make those disclosures and to whom and in what order may matter, right? In terms of being able to keep them as anonymous or confidential as possible. Some people may be like, I don't mind having my name attached to this information, but I don't want to talk to the press, right? And so there are other mechanisms that one could use to both insulate against retaliation, as well as exercise your speech rights. So again, it depends. It depends.
I know that's the answer for so many things.
But it means that there is not just one avenue for general civil servants. I mean, if you're military or intelligence, those are exceptions. But for general civil servants, they have a lot of different options. And Joe, you may have some other thoughts about that.
Yeah, and Joe, before you jump in, let me just pull a thread on one thing. So Dana, you mentioned intelligence. So you're saying if they're in one of the intelligence community agencies, so one of the 3-letter agencies out there, they're going to be under a different.
They're under a different scheme. They have rights to report problems. They just have to do it in a very special way and a special order. Yeah.
Got it. Okay. Oh, Jackson, before we let Joe jump in, I see you coming on screen with a question.
Yeah, sorry, Joe, and maybe if you have the answer to this one, you could take it. But we've had a few questions related to the news reports around inspectors general being fired over the last several weeks. And so I wanted to ask sort of, can individuals still whistleblow to their IG office if that position is vacant? And is there anything that a federal employee whose inspector general office is vacant should think about in whistleblowing to that office?
Yeah, I can jump in, and then I certainly, would like to hear from Dana as well. I know that this is certainly an issue that's been top of mind for so many people over the past several days. One thing, I mean, it really speaks to what Dana is talking about, how there are lots of different avenues that are available, but they each come with their own distinct risks and opportunities. And so, generally speaking, of course, inspectors general offices are supposed to be independent of their agencies. Sometimes that's not the case. We've seen instances where they act more to protect the agency, including the agency's public image, rather than working more closely and honestly with a whistleblower and to investigate their concerns. There have also been times when they've been sources of retaliation against employees. And I think, especially with these recent firings, it really can cause a lot more distrust and confusion depending on, what is happening on the ground right now, who those IGs are replaced with, and what can really establish a chilling effect is to the extent that people in those positions are not seen as independent of the administration, that they are seen more through a political lens, and that can really cause a lot of distrust over time that'll prevent whistleblowers from coming forward and really make it much more difficult to really fulfill those core missions of their offices. And so you can still bring disclosures to the IG's office. But again, I mean, I think there are just lots of different risks and considerations, especially at this particular time.
Dana, anything to add?
Yeah, I would just echo that. Like, in some ways, this is the reason you're having this explainer series is because of what is happening right now, right? And so in some ways, we're talking about, oh, here are your rights and here are your options. And it has always been hard to choose to blow the whistle, right? It is always, I think about the primary reasons employees stay silent in the face of wrongdoing are fear of retaliation and fear of futility, that speaking up won't make a difference. And both of those have always been very real concerns. When you see IGs being like completely taken out, which are supposed to, again, as Joe said, be the independent monitors, right, of against fraud, waste, and abuse. That's creates a heightened risk of fear of both retaliation and futility. And in this environment of where political violence has become a norm, it's that much more fraught. So I think it's a real issue. And I think what's so important about the apolitical nature of these accountability mechanisms, it's also a point about the apolitical nature of whistleblowers historically. I mean, they have enjoyed bipartisan support. There have been whistleblowers across every administration. And they don't want to be politicized. That's the one thing that they do not want, right? They do not want to be politicized. And that is they want the message to be addressed. They want the underlying problem that is prompting them to speak, that they cannot stay silent about, to be addressed. And when these mechanisms of accountability are threatened, that may create a chilling effect, right, on people choosing not to speak out. And at the same time, I think that there are still mechanisms that aren't just IGs, that are protected, that aren't just the Office of Special Counsel, because we had, Hampton Dellinger was fired Friday and is now suing because that was an illegal firing. The mechanisms of accountability to protect civil servants' rights to speak out, which protect all of us on every issue of public concern, are under threat. It's why communicating with Congress might be important, selectively communicating with Congress. It may be why communicating with public interest partners like POGO, and the press become important, but in ways that employees are wrapped around their rights to speak out. So it's a really different operating environment that you guys are all living in anyway. And there are ways to still speak up and make a difference. And we have seen it time and time again be one of the only things that does sometimes. So it's terrifying. And I don't think it's hopeless.
And I think that's a time to step back and say, okay, we've talked about why blowing the whistle, what is a whistleblower? What about the process for, because people are sitting here, they've heard you mention the Office of Special Counsel, they've heard you talk about who to make disclosures to. If somebody is going to blow the whistle, what's the general process that they would go through? Do they need an attorney? Do they come to different organizations? We've talked about the IG and some of those, but walk us through an example of what that looks like.
Yeah. Do you want to take that, or do you want me to start, Joe?
Why don't you start, Dana, and then Joe,
okay,
if you want to jump in.
Okay. I can give, I don't know if this is helpful, but I can give an example. I'll give an example of some, public clients that maybe, I don't know how this will play out, but let's just try. And I think it's a good example because it's a good example of the one of the first things they did was they came, not just us, they came to attorneys to get advice about whether, how they could speak up about, and this was in the context of the separation policy, and how when they were separating kids from families at the border in 2018, the two doctors who were they were contractors. They weren't civil servants. They were government contractors for Department of Homeland Security, Office of Civil Rights and Civil Liberty. And they had been doing inspections of family detention centers for years under the Obama administration and had been advocating for closure because it was very clear that detention causes harm to children. And so when during the Trump administration, the Trump 1 administration, they started separating kids from their parents at the border. Part of the move in response to that was, we'll stop doing that, but we're going to detain families together. And they were like, well, that's that's maybe seems not as bad as separating kids from their parents, but it's still actually very dangerous, and people are going to die. And so they came to us saying, we can't stay silent about this. Can we write an op-ed, because we have a non-disclosure agreement? So that's what they came to us for. And we were able to help talk to them about their goals and about their concerns and risks. Like, were they scared of being fired? What had they done so far? We told them that their First Amendment rights were actually much weaker than their rights as government contractors to blow the whistle. We helped them, and we also were able to explain to them that non-disclosure agreements are gag orders are essentially illegal. Your whistleblower rights supersede non-disclosure agreements, and that's important information that most civil servants don't know. Because they're inherently chilling and you can challenge them. But basically, we helped them together, go through a disclosure process that was very ordered. Like, we had them first file disclosures with the Office of Inspector General, which is first with their management, and let them know that they were exercising their whistleblower rights about this concern. About the concern that family detention was going to harm people, with very specific examples that they had. We filed disclosures with the Office of Inspector General, which receives contractor disclosures. For a federal employee, we would have sent a disclosure to the Office of Special Counsel, because they have rights to receive disclosures. Then we sent it to Congress. And then the disclosure to Congress was publicly available to the press. So they went through all these different mechanisms to entities that are there to receive whistleblower disclosures, because it also created a sense that we're trying to go through, the right mechanisms. We're not going straight to the press, even though they could have. We did it in a way that was protective. But that, catalyzed, it was part of hearings that happened, people being questioned in hearings. Then they ended up being on 60 Minutes. They ended up receiving hero awards. Kids were, their disclosures were referenced in other petitions to release minors from immigrant detention. Family detention was ultimately closed at the beginning of the Biden administration. So that's a good example. Again, it's a great example of how whistleblowers can, with support early, be wrapped in their rights and be helped through a process that's gradual and incremental to disclose information in a very deliberate way to different entities in ways that are safe and strategic, and that can also make a difference. And so that's just one example. That's you hear the horrible examples of, like, I blew the whistle and my life was ruined. And there are actually a lot of stories about how to do it in ways that can be safe and effective. I think the first step is talking to an attorney who does know how to navigate a very complicated process.
Right, because to your point, there's a lot that goes into this. Does somebody have to, you said something that actually, because I know a little bit about the process, but raised the question, does somebody, when they make a disclosure, have to self-acknowledge that they're blowing the whistle in order to have the protection? So they have to say, I'm a whistleblower, I'm coming forward with this, or are they protected because of the nature of their disclosure?
They are.
I asked you a hard one.
you did, because, for instance, you can maintain your confidentiality, right? You can make a confidential disclosure. Like, for instance, I could file a confidential disclosure on behalf of anonymous whistleblowers with the Office of Special Counsel, let's say, or with an IG, and I would be their spokesperson, if that makes sense. It would be where it becomes, and that's a fine thing to do. Where it becomes harder is if you're showing, if you have to, if you end up being retaliated against because you blew the whistle, but they don't know if you're not named. It can be harder to show that the reason you suffered the retaliation was because of your whistleblowing. But it's also why I say anonymous whistleblowing it's not only that it's it's hard to promise. Like, I would run away if someone promises that they can keep you anonymous no matter what, right? It's actually because your fingerprints are on it, just even if you're not named, right? There's only a small constellation of people that might have that specific information, for instance, and so it can be easy to identify the source, but it also might make it harder for you to prove a retaliation claim. And at the same time, there are ways to maintain your confidentiality, and have the information out there be insulated through through an attorney or through another organization, have that information out there, and have something done about it. So you don't always have to be publicly named.
Got it. And Joe, I don't know, one other question I have, and I don't know if this is towards you or towards Dana. You both have so much knowledge in this space. What sort of, if somebody's going to blow the whistle, they've seen, something that rises to the waste, fraud, and abuse category, what sort of, particularly if they're going to an outside organization or to Congress or to the media, what sort of proof, for lack of a better word, what sort of examples of waste, fraud, and abuse would they come to either Pogo, Gap, or an attorney with? What does that look like?
Yeah, so by law, whistleblowers are not required to have absolute definite proof to substantiate an allegation. The way that the law is written, they just need to have a reasonable belief that their disclosure meets, these certain criteria. That being said, it can be really, really helpful to have as much of a paper trail as possible. So collecting evidence from emails, letters, meeting notes, correspondence, personnel files, contracts, any sort of work product. Also, reaching out to potential witnesses, close trusted colleagues who, will have your back and substantiate the information that you're bringing forward. All of that is really, really helpful. One thing that I'll just highlight, which is a concern, is that a lot of whistleblower disclosures get thrown out for a lack of evidence. And so that's not saying that there wasn't this wrongdoing, but just that it's really important to have as much corroborating evidence as you can. And that's something that by consulting with an attorney as soon as possible, they can also help you walk through ways to strengthen those claims.
Great. Jackson, jumping in with a question.
Yeah, thanks. And I think this question really gets at the operational sort of components of whistleblowing. So we had some questions just around, first, how long does this process take? If someone reaches out to Congress or an IG office, should they receive a response, a reply? I think, Joe, maybe to your point of lack of evidence, you could talk to that. And then if they're going to receive a reply, and then afterwards, how long does the process take, and what sort of timeline should individuals expect?
Dana, you want to?
I'll just give
Joe, you want to go for it?
Well, yeah, I'll just give kind of like a general overview because, as Data said up top, so much of this is very circumstantial dependent, especially depending on who you're disclosing to. Certainly when you're working with the media, outside organizations, you might have more ability to control the process and that you can disclose over a period of time based on your terms. If you're disclosing to members of Congress or a congressional committee, they have their own priorities and timelines and everything like that. There are statutory provisions when you're disclosing to entities like the Office of Special Counsel or an IG office. We often see those timelines, really go out the window in a lot of ways. There are lots of opportunities for extensions, or agencies just do not abide by those timelines. And so it's not uncommon to see the length of time really drag out, and it can be difficult to really know what's happening if your disclosure is being taken seriously, when you might get a response, if any response, and if it's really being dealt with. And that's even before, if you do experience retaliation and want to file a retaliation claim, I mean, that's a different process. And that's something that can also drag out. And so it's another thing to really keep in mind when you are making an informed decision, that this process could really take a long period of time.
Dana, anything to add to that?
I don't have any positive blush to put on anything you just said, which is I think that it can take a long time. I think things can move incredibly quickly depending on the nature of the disclosure. And again, as Joe said, like depending on the constellation of pressure points, people care about disclosures of fraud, waste, and abuse often, right? And they also care that employees, if they suffer retaliation, right? Like I think that, like we have seen in very significant cases, very rapid responses to whistleblowers' disclosures. I think about like during COVID, the OSC had set up like a rapid response team where they were actually, doing very rapid handling of intakes around COVID. And they would just push investigations into disclosures through. They would address retaliation claims very quickly. So there have been examples of an ability to move very quickly in the face of serious wrongdoing. And I think I was going to say, I think this relates in some ways to the difficult choice that people make around whether to speak up. It kind of goes to Joe's point, like knowing your rights, risks, and options. Like your rights, they're not great, honestly. They exist, though. It doesn't mean enforcing them is easy. It doesn't mean you're not going to suffer retaliation for blowing the whistle, right? That can happen. It just means you have a right to seek a remedy, and that can take a long time. But you also might suffer retaliation or lose your job anyway, right? So in this environment, and it's a different calculus possibly. I think that so often we see employees, like we often counsel them, you need to think hard about whether or not this is worth blowing the whistle on. This can take a long time. Is at the end of the day a remedy going to be something that's satisfying to you, even if you're vindicated, right? Like I think that is a really important question. Or do you just move on? At the same time, we see people all the time who are like, I couldn't look at myself in the mirror, as like my colleague says, like I couldn't stay silent. And so I think that, and they can make a difference. And we've seen it again and again on every issue of public concern. I think about why whistleblower laws are such a patchwork of protections. It's usually because someone blew the whistle on something that was really big, and then they need to make a new law to both protect the whistleblower and address the wrongdoing that the whistleblower exposed. And so we see so many environmental and consumer protection laws because of that, so I think that the law matters. It creates a grounding of insulation, as well as like we have decided as a society that it's important for employees to speak up and to not suffer retaliation for doing that. And that means something. And exercising those rights can be challenging.
Just like everything else, right? It depends.
Yeah.
I mean, that's the takeaway from so many of the things we've had other webinars talking about. Some of the personnel actions and that happen, in retaliation is certainly one of those for a variety of things. And so, right, it's a balance of understanding your rights, understanding the risks, and seeking guidance and help on figuring out how to navigate both the balance and the system. Is there anything, we've talked a little bit about the protections that civil servants have. We've touched on them a little bit, but it's really going through Office of Special Counsel for retaliation claims. Are there other protections that employees have? I mean, that people have heard about Merit Systems Protection Board, they've heard about other things. So just wanted to clarify for folks, what are those types of protections that federal employees have?
So, so if we're talking about under the Whistleblower Protection Act, which was amended by the Whistleblower Protection Enhancement Act in 2012, again, they have rights to report information that they reasonably believe evidence is a violation of law, rule, or regulation, gross mismanagement, gross waste of funds, abuse of authority, or substantial and specific danger of public health and safety. They also have rights, federal employees also have rights to report scientific censorship that would result in any of those other kinds of wrongdoing. So scientific censorship that would result in those problems. I should note that they don't, policy disputes are not protected disclosures, but consequences of policies are. So if the consequences of a policy would result in abuse of authority or gross waste or gross mismanagement or illegality or harm, those would be protected whistleblowing disclosures. They also have, and so I know this isn't, I'm sharing this because I think it's important about what you get to exercise and then where you get to exercise it. There's another piece that we haven't talked about, which is your right to refuse to obey an illegal order. Which is a different, it's like kind of post-speech almost. Like usually you have raised a concern if you're in the process of refusing to obey an illegal order. That is not a reasonable belief standard. That burden falls on the employee to say this is an illegal order and to prove the illegality. So it's a much higher standard for an employee, but they still have a right. And these are all codified under 5 U.S.C. 2302. That's where you want to look, 2302 B, 8 and 9, primarily. They have rights to, if they suffer retaliation, to file a retaliation claim with the Office of Special Counsel, and they can have an individual right of action to go to the Merit Systems Protection Board. And so that is like the it's like the trial, but it's actually the kind of like the appellate level. And then the board decides the retaliation claim, and then you can appeal up to the Federal Circuit Court of Appeals. You do not have a right to remove to federal district court for a de novo trial. You do if you're a federal contractor or grantee, not if you're a civil servant. Your civil servants, your rights are weaker as a federal civil servant, unfortunately, as a whistleblower.
And you need to also know, have somebody who can help you through that process.
Exactly. There are other laws that do protect federal civil servants. So and again, I'm accepting there's a Military Whistleblower Protection Act. There's a separate scheme for intelligence community. So, but under some of the environmental laws, which are usually protecting corporate employees, there are employee protection provisions in them that like 7 of them, I can't remember which ones, but 7 of them apply to federal employees as well. Those are basically enforcement schemes. If you see like a violation or a potential violation of that law of like the Toxic Substance Control Act, for instance, I don't remember if that's the one that's covered for federal employees, and I can look real fast. But so there are a few other options, which again is why it's good to talk to an attorney, because it is a patchwork of protections, and they have different places that you go. Like Department of Labor handles the environmental and consumer law scheme, so it's a different administrative forum to play ball in.
Right. I mean, that's, again, it's complicated, which is what I feel like we're saying throughout this whole webinar series that we've been doing, is it's complicated. Joe, one more question that comes to mind, because I know we're getting close to the end here. Is there a difference in whistleblowing? Yeah, obviously, we have military, contractors, and intelligence community, but just to clarify for folks on the phone, on the video, phone, I don't know which era I'm in here. If you're a senior executive, if you're a competitive service employee, if you're a bargaining unit, so you're a union employee, do the laws, Whistleblower Protection Act applies to all of them, I believe. Is there any difference depending on what your status is, whether you're accepted service or not? I don't know if either of you know. I just thought it'd be good to clarify, because so many other laws, it depends on your status, which level of employment you are.
Political appointees are not protected under the Whistleblower Protection Act, but senior executive service, exempt and competitive service, and probationary employees are all covered under the Whistleblower Protection Act.
Okay, I hadn't even put probationary in, because they've come up in other.
Yes, they have. Yeah.
So,
yeah.
Okay. That's helpful. Well, I know we're getting close to time here, and I know we didn't get through all the questions that have been coming in, but I did want to give each of you, because I've seen in the chat some resources go through, give each of you a chance quickly to mention some of the resources out there that folks might want to look at if they're, if they've come across any need to blow the whistle, or they just want to learn more about the process. So Joe, do you have any resources to point out? And then Dana?
Yeah, I'll definitely just make a quick plug for Pogo's website. We do operate a tip line on our website, so it's really easy to submit information there. There's also a lot of great tips about communicating through safer channels, a lot of detailed reports and information. We also, certainly work closely with people across the political spectrum, and we have a good reputation of being an honest broker that can really help us facilitate conversations and advocacy efforts that make us more impactful. And so, yeah, please check out our website. I know there are lots of other different resources through GAP and Civil Service Strong and the partnership. But I just really want to emphasize our appreciation for the federal workforce. We're really grateful to partners like the partnership and GAP to have this opportunity, and collectively we will be standing together and ensuring that as we are navigating difficult circumstances, people are apprised of their rights and protections, and exactly how this can play out, so that when you're faced with these decisions, you can make as informed decision as possible for yourselves, your families, your jobs, and careers.
Yeah, thank you, Joe. Appreciate that. And Dana, I think we put some other resources in there as well for you.
Yeah, it's so helpful. I will point the partnership has been so great at putting resources up and having FAQs in this great webinar series. I will plug civilservicestrong.org is another kind of curated place for a lot of different information from a lot of different, like from unions, from nonpartisan organizations that are sharing their resources, Pogo, us, Government Accountability Project, Peer, Crew. So a whole bunch of us have a bunch of information up there. And so that's a great place to look for a lot of different answers. For us, we are a nonprofit organization. We are trying to we focus on whistleblowing, but we also recognize that civil servants have a lot of different questions. So we are very active, like Pogo is, with others in this kind of good government space. We can offer referrals to other attorneys who are experts working with federal employees. We can help direct folks to the right places. So you can find us at whistleblower.org. On every page, there's a Seek Assistance button. There are lists of resources, there are many of which are in this chat here. So I think I also put in a plug for Public Employees for Environmental Responsibility here. They actually do represent environmental whistleblowers specifically. So there aren't enough of us out there to help all of you. That's the hard thing. And at the same time, I will say that it has been very encouraging. We also just launched a project, Justice Connection, where for DOJ alum, helping DOJ employees. There are so many attorneys and organizations working together right now to try to share capacity and collaborate to ensure that civil servants have the protections that they need and to protect the institutions of democracy. It is kind of an all hands on deck moment to make sure that the institutions of accountability are effective, that the civil servants who are part of those mechanisms of accountability and doing the work of the public, of the civil service, right, are supported and protected. So I know it feels very confusing right now, and I'm so sorry about all the it depends answers to these questions. It's complicated because you feel really confused, and I get that. So many of us are bending over backwards to offer help, like the partnership is. And I'm just so grateful for the partnership and for all the partners in this space who are working together to make sure that we are trying as hard as we can to offer you information, resources, legal support, as well as a degree of empowerment that you have you do have rights. You do have options to speak up about problems that you are seeing, not just that we're all seeing, but the consequences that are going to start becoming very severe. And so getting help navigating those rights and understanding your risks and your options is just invaluable. And we're here to help as many people as we can.
Great. Thank you both. Really appreciate you both being here tonight. Appreciate all the folks on the line here. All the questions, please keep the questions and topics coming. As Dana and Joe both said, a lot of organizations are here trying to help people make sense of what their rights and responsibilities are, what are the different issues and topics out there, and how to navigate those. So please visit all of our resources, and there's more to come. I know we have a bunch coming up on the partnerships website, more FAQs in plain language, but stay tuned for those. And we've got a couple more webinars coming up this week, another one on Wednesday about understanding your benefits and retirement benefits and healthcare and all of those in context of a lot of different employment and personnel actions. So with that, I will just say thank you to our guests, thank you to the team that helped produce this, and to all the federal employees out there. Thank you so much for the work that you do day in and day out to serve our country. We really appreciate you. Have a great evening.